Me record.
Are you gonna?
And I'm sorry, should I introduce you?
Sure. No, come on.
Let's go.
Hey, good evening, everybody. I'm Andy Rosenberg. There's a few people here, and there's a lot of people on the Zoom. So bear with me. It's kind of an interactive workshop today. Again, I'm Attorney Andy Rosenberg, and I'm here to talk about estate planning. Hopefully, estate planning essentials. That's what we're here to talk about today. Real quick, just a background about me. My firm, the main office is located in Coral Springs. I have satellite offices that we can use in Weston and in Boca. And I have another office in the Cooper City area that I have access to if we need to meet. But I do a lot of meetings with people by Zoom or in person or a telephone or however it might be. I'm originally from Indiana, believe it or not. My wife is from South Florida, and we met in college at Indiana University, and that's how I ended up down here in South Florida. So let's talk about estate planning. That's the goal tonight. I'm going to try and get through this in about 45 minutes to an hour at most. Carlos over here is going to keep track of me, okay? And I expect questions from you guys. So I'm here to answer questions. So I don't know, how am I going to hear the questions? How's that work?
They're gonna say it, and you will hear them.
Okay. All right. So I'm going to talk, but if you have questions, just start asking questions. And then if I have to move it along, I'll move it along and I'll tell you we got to move on. Okay. So here we go. All right. So there's 4 things that I want to talk about first. One is hopefully you're going to have a good time. I try to make this as interesting as possible. I mean, guys, we're talking about debt. Okay. So it's not the most exciting topic here, but I'm going to try and make it interesting and worthwhile for everybody. Okay. Number 2, it will go fast. I've been doing these workshops for about a year or so in different locations throughout the Tri-County area, and they go pretty quickly as far as the time because it's usually very interactive with the clients. But this is the first time I'm doing a combination here, so we'll see how it goes. Number 3, hopefully everybody's going to learn something. And then the last thing, normally what we do for the people that are in here personally live, we have an evaluation form, and over here I have Carlos collect the evaluation form so that I can get your feedback on how I did and how I didn't do, if I missed something or there wasn't something worthwhile, or something that I missed topic-wise that you wanted me to talk, so I can add that to future workshops, okay? All right, so here we go. Here's what we're going to do. I have a bunch of topics. The first topic is what happens if we don't plan at all. We're going to talk about that. Number 2 topic is a will equals probate. That's a huge misunderstanding, and we're going to talk about that topic. Number 3, we're going to talk about titling of assets. It's an extremely important topic that I go through in detail, and most attorneys just kind of gloss through it. It's a really important detail in estate planning. Number 4, we're going to talk about, has anyone ever heard of a ladybird deed? I got one in here. We got 2 people. Okay, we're going to talk about that and let you understand how that works. Then we're also going to go into what I consider the 4 most important documents in an estate plan. All right, and it may not be what you think it is. Then we're going to talk about trust work. Then we're going to talk about funding of trust and what that means. And the last thing is, for real quick, I'm going to talk about Medicaid planning. Let you understand what that is, and because I'm an estate planning attorney and I'm an elder law attorney that deal with people trying to get on Medicaid purposes for estate planning. So that's a lot we're going to talk about. So I'm going to whiz through this stuff. Again, if you have questions, you need to just go ahead and ask the questions as we go through. Okay? I got thumbs up here.
You want to see thumbs up? He got thumbs up. Everybody can hear.
Everyone okay? I just want to make sure I can't tell if there's thumbs up.
Okay.
Are we good?
There go your thumbs up.
All right. All right, first topic, we're going to skip that. We're going to skip that. We're going to skip all these, so it's not important. All right, so here's the first important slide. I put hide, but that don't worry about it. So here's the first question. Who needs to do estate planning? The answer is everybody. Okay, so there's a huge misunderstanding out there in the world that you have to have $1 million or a ton of money to do estate planning, and that is completely false, guys. I don't care if you have millions of dollars or if you have nothing to your name. Even people with nothing to their name really need estate planning. I'm going to give you a quick example. How many of you out there have kids that are 18 years of age or older? I have two. Okay, and I see a bunch of people raising their hands in here. So I have two kids. So when kids in the state of Florida turn 18, they're technically considered adults. And so when the kids go off to college, and if something happens to those kids and they need your help, they're in a hospital, God forbid, they're in a car accident or something like that, you're not going to be able to talk to the doctors or the hospitals because they're technically adults. But guess what? If we have the proper estate planning documents in place, you would be able to talk to the doctors and the hospitals in that situation. And guess what? The kids that are in 18, 19, 20, 21-year-olds in college, they don't have any money. So I'm just trying to prove a point that you need to get this out of your head. Everybody needs estate planning, okay? That's the most important thing I want you to understand tonight, is that I don't care how much you have, you do need some basic estate planning. All right, so now let's first talk about this topic number one. Topic number one is if you don't plan. And what do I mean by that? I mean, does anyone know? Well, it's kind of hard to answer questions. Well, I'll ask the question. Let's see if anyone responds.
Yes.
Does anyone know legally what you call the term, the legal term, for when someone dies without a will? They have no estate plan, nothing in place. Does anyone want to try and guess what that term is called? I heard it.
Intestate.
Yep. Intestate. Intestate. That means dying without a will. Okay? That's all that means. Now, let me explain to you how that works. I'm going to use an example. I'm going to use my house. I live in Weston, not far from here. Okay? I live in Weston, and I'm married and I have two kids. So the house is in my name and my wife's name. But for example purposes, we're going to assume the house is in my name alone. It's not in my wife's name. Understood? Then, let's say I drop dead, God forbid. I drop dead, and the house is in my name alone, and I don't have anything in place. So I die without any will, without anything. So I'm dying intestate, dying without anything in place. What happens? Probate. And that's what everybody said in here locally. That's right here live. And that is correct. We're going to have to go through probate court. Does anyone want to guess what I consider the three problems with probate court? Number one, I just heard it. She says it's expensive. That is correct. Let me give you an example. My house, I bought way back when, because I'm an old person at this point, but I bought way back when for $359,000. My house today is worth about 1.8 million. Okay. I'm going to just round it house to say it's worth 1.5 million for ease of purposes. Anyone want to guess if my house, if I die and the house is in my name alone and I have nothing in place, we're going to go through probate court, which we just talked about. How much do you think it's going to cost to go through probate court with a house valued at 1.5 million? $10,000
And more than 5,000.
More than 5,000. How much? 500,000? Is that what you said? Yeah, no. So the answer is there's a Florida statute. It's called the Florida Intestate Statute. And basically it tells you what is a presumed reasonable fee that I can charge for a probate in this situation. And it's 3%. So 3% of the value. So if you got a $1.5 million house going through probate, 3% of that is $45,000 in legal fees. It's a lot of money. I didn't even talk about the personal representative or executor. Okay, the person in charge. You've heard the term executor, but in Florida we call it a personal representative. They're entitled to the same fee. So it could be 6%. It could be $90,000 in that example right there. So the number one problem with probate is expense. What's the number two problem with probate?
Time consuming.
Time consuming. Very good. Time consuming. Anyone want to guess how long the process takes to go through the courts with probate from start to finish? Give me a guess. 6 months, I hear.
6
2
months
years.
to like 3 years.
6 months to 3 years. Well, that's a pretty broad range, isn't it? So the national average for probate is about 18 months. Okay. Florida's kind of right around there. we're pretty close to that because here's what you need to think about. In Broward County, I believe we only have, I could be mistaken, 3 judges that handle probate court. That's it. There's only 3. And guess what? Judges go on vacations. Judges get sick. Judges have emergency hearings. Things happen, right? These are all causes for delays. So that 18 months, you can see how that can happen pretty quickly. Let me explain to you the beginning part of probate so you can understand why it takes so long. At the beginning, now we're still talking about if I die without anything in place, intestate, right? So what happens? Well, we have to file a bunch of opening documents with the court. So we have to fill out documentation and we have to file it with the court. The court has to okay it and say it's good. If everything is good, they're going to issue me a case number. When they issue a case number, I then have to send to the court a certified death certificate. Once I send a certified death certificate, then I send another document hoping the judge will sign off. It's called letters of administration. And that is the legal document that officially appoints the executor or personal representative in the estate. Once the judge signs off on the letters of administration, I then have to publish in a newspaper for 2 weeks in a row. And then I have to wait 3 months before I can do anything because we got to see if any creditors file against the estate. So that's just the beginning. And that's probably about 3 to 5 months before we even do it, right? And that's just the beginning. So you can imagine how 18 months can happen pretty quickly. And also imagine if there is litigation involved, forget it. It could be a couple years situation. So again, number 1 problem with probate is expense. Number 2 problem with probate is that it takes a long time. What is the 3rd problem with probate?
Fighting with siblings? Yeah.
That's they said fighting with siblings over here live, and that is true, by the way. That happens obviously, but that's not what I was thinking of. What I was thinking of is it's public record. Probate is public, okay? And a lot of people, I'm private. I like to be private. I don't like to talk about my stuff. I don't want people knowing about my business, none of their business. Tonight I'm going to talk about stuff because I'm talking to you guys to help give me an example of how things work. But I tend to be a private person, and most people tend to be private people. But unfortunately, what happens in the probate process is it's all public. So anyone can go to the courthouse and look and see what's going on. I'm going to give you a quick example of why that's bad. Let me give you an example. When I was a young attorney, many years ago, okay, when I was a young attorney, I did probate back then also. And I had a widow who passed away. And we did that opening in the probate process. I just explained to you guys. And then we published it in a newspaper for 2 weeks in a row. We waited 3 months. During that 3-month period, I had a roofing company file a claim against her estate, saying that they were owed 50% of the roofing job. And they said that she signed a contract, and they showed us the contract, and they showed us the money, and they said she has not paid that yet. That needs to be paid from the estate. I thought something didn't feel right. So I did some extra work and some fishing around. And it turned out that that roofing company was fraudulent. They actually, what they did, back then you could do this. You can't do this today. But back then what they did is when we filed a new probate, they went down to the courthouse and they pulled up the will. And then at the will, you could see the signature of the person that died. They forged that signature onto their contract and then filed it. So that's how easy it is to have fraud on the court back then. It's gotten harder, but don't think that there isn't fraud on a daily basis, okay? Now, here's another problem with dying intestate, especially if you're in a second marriage, okay? Or a third marriage, and you got kids from prior relationships and all this stuff. I promise you, if you die without anything in place and have to go through the Florida intestate statute, the state of Florida is going to tell us how your assets get divided. And I promise you, if you are in a second or third marriage situation, you have kids from other situations, you are not going to like how they decide it goes. So if you learn one thing tonight, never die without anything in place. Never die, never die without a plan. Any questions so far? So far, so good?
Okay.
Any questions?
No, no question.
We're good?
Any questions right now? You can unmute yourself and you can speak. We can hear you. Okay.
No? Okay, so now we're gonna go, so we talked about what happens when you pass away, the probate process, the intestate laws, I just spoke about all that. Okay, now let's talk about this. I like this slide a lot. It's not the most exciting slide, but it's really important. What actually is estate planning? Obviously, if you do nothing, that's not estate planning, right? So what is estate planning? So here's what you guys need to think about as we talk about the rest of the topics tonight. It's three core elements. Number one, who's in control? Number two, who gets the benefit and when? Is it when you're alive and well? Is it when you're disabled, or is it when you pass away? Everything we're talking about, all this stuff we're going to be talking about, I need you to think about this slide during the process, because that's really what you're trying to decide. If something happens to me and I become disabled, who's going to be in charge? And are they going to be charged in financial affairs or healthcare decisions? These are the kinds of things you have to think about, and that's what this estate planning is all about. All right, next, going to topic number two. Topic number two is wills equal probate. So here's another question for you. So I'm standing over here. I'm not going to move around, but if I can. Okay, so if I'm standing over here, I died without a will. I died intestate, right? And then the state of Florida determines where the assets go, and we go through probate. I'm going to stand over here. You can still see me. No, I can't see. Okay,
They can see you.
yeah, but I don't know how to follow. It's too far. I'm going to stand back over here. Okay, so now, let's say the same scenario. Okay, the same scenario, except I have a will. Does anyone want to know what that? So I have the house in my name alone, and I have a will. What's the legal term for dying with a will? Anyone want to get? Without a will, it's called dying intestate. Anyone want to guess what dying with a will is called? There we go. I heard it. Testate. Testate. What happens in that situation? Well, remember what happens in the intestate. Dying without a will. We go through all the hassles, delays, expenses, and the probate, right? At the end, the judge will say, where's the asset go? And we look at the intestate law, and it tells us how it goes. Now, I die with a will. What happens? Same thing, guys. Okay, same thing. I go through all the hassle, delays, expenses, and probate. At the end, the judge is going to say, where does the asset go? And in this situation, we look at the will, and the will determines how it goes. That's the only difference between dying without a will and dying with a will. That is it. And I give this slide. I used to do lectures 32 years ago, okay, at the beginning. And this was my only slide I ever did. And I talked for an hour about this one slide. And here's who I blame. People think that if they have a will and they have less than a certain amount of money, that it just automatically goes to them. Let me give you an example. One of my favorite movies is called Gran Torino. Anyone seen that with Clint Eastwood?
Yes.
Great movie, right? At the end of the movie, what happens? Clint Eastwood, spoiler alert, if you haven't seen it, Clint Eastwood gets killed. They're all the beneficiaries. They're sitting in the attorney's office. The attorney's reading the will and telling everybody who gets what. And then at the end, his friend that he made, his Oriental friend that he made, right? He gets to Gran Torino and they show him driving off into sunset and then the credits roll. That's the movies. That is not real life. They forgot a small little detail there. Something called probate court. Okay? So that beneficiary would not get that car for probably 12 to 18 months or longer because of the probate process. So what you need to understand is, I don't care how much money you have, if you have assets that are in your name alone, when you die and you have a will, it's still going to go through probate court. Got it? That the only difference between intestate without a will and testate with a will is how it gets distributed at the end. Both of them go through probate. Got it? Questions? Any questions from anybody at home?
No.
Do we have any questions?
Any questions at home? Anybody have any questions? Online, on Zoom? Anybody on Zoom have questions?
Is anyone paying attention?
Yes, we are.
Yes, sir. Everybody is here. Listen attentively.
Okay. Am I boring the crap out of you? Or is it okay?
No, sir. I'm writing down notes.
Okay. No other questions? Then we're going to continue on. All right. We're going to talk about, we already talked about probate. It's in the slide that explains that. Remember, dying without a will is called intestate. Dying with a will is called testate. Either way, you're going through probate. The three problems with probate: expensive, time consuming, public record, and no control. Right, the court's control. So the question is, how do we avoid this whole mess? And that's what we're going to talk about. All right, and then we already talked about what's bad with probate, so I'm just going through this. I'm going to skip this slide. Well, actually, let me go back. So my son, Jason, is in law school, actually, at Duke University. Okay, go Dukes. So when I went to go visit the school with him at the hotel, when I woke up in USA Today, there was an article, and it says in this article, estate planning is in decline with fewer of us writing wills. The new survey finds, and you can't see it online, but way up here it says April 4th, 2024. Okay. So a year and a half ago, he's in second year law school. And here's the scary thing. I've been doing this for 30 plus years as an estate and elder law attorney. Estate planning has been going in decline from day one since I've been doing it. It's gone down. People are not doing it. Why do you think people are not doing estate planning?
Because they think that they don't know, and because they think a will is sufficient.
Right? Can they hear you?
Yeah. Can you hear me?
Yes,
With my,
yes.
yeah. Okay, everybody can hear.
Okay.
Very small.
Okay. So they think a will's sufficient, right? That might be a reason. They think that they don't need it. That might be another reason. I'll give you a real good reason. They don't know. A lot of people don't know, right? How about procrastination? Yeah. People, here's the biggest thing I see, and I've been doing this a long time, and attorneys can attest to this. People think that they'll just push off their estate planning stuff till the next day. I can wait till tomorrow, right? Guess what? Sometimes you don't have that tomorrow. I can't tell you how many times that we have seen it in my office where the tomorrow is no longer. The person died. Okay? And I have I'm not going to play it, but I have on my phone my gardener who called me up and said, I want to meet with you to do an estate plan. I called him and left a message for him. He didn't call me back. Called him the next day, left a message. Called him a third day. His wife picked up. He dropped dead between when he left the message and when he wanted to meet with me in 3 days. He dropped dead of a heart attack in his early 50s. So don't think it won't happen to you, because I'm going to tell you a story about myself at the end of this workshop as well. Okay. So, but here's what's interesting. So people are afraid they procrastinate, and they're afraid to face mortality. People think when they do this, now they're going to die, which is ridiculous. Okay. You're going to die when it's your time, no matter what, whether you have an estate plan or not. So get that out of your head. I will tell you the one time that estate planning went nuts, like it went way up. Anyone want to guess when?
COVID.
Yeah, COVID. You know why? Because on TV every day, you guys, we're seeing how many people are dying on a daily basis, and you're thinking, oh my God, that could be me. I better deal with it now. And so I was crazy busy during COVID, right? I'm crazy busy now, but it was a crazy time during that period, okay? And I've had several clients that died during COVID. So it happens. I just wanted to realize, don't be a procrastinator, okay? Do not procrastinate about estate planning. All right, titling of assets, really, really important. So estate planning, obviously we're dealing with a will and a trust and all that kind of stuff, but you need to understand how important it is, how things are titled to determine how estate plan will work. And so we're going to talk about this for a few minutes. So first thing I'm talking is what happens to your assets when you die? Well, it depends on the titling of your assets. Okay, we're going to talk about joint tenancy, tenants in common. We're going to talk about stuff like that. We're going to talk about TOD and POD, transfer on death, payable on death, beneficiary forms. That all tells us how things are going to go. Okay, and that determines probate, no probate, all sorts of things. So let me give you a quick example. You guys probably, I don't know if they can read that online.
Yeah, they can see it perfect.
Oh, okay. So I'm gonna give you a quick example of what I see a lot. So I have Mary, who's a widow, okay? Mary's a widow, she's got 3 kids. One of them lives locally here. And then the other 2 kids, one lives in California, one lives in New York, right? Mary's getting older, and she said, I need help writing checks and doing things. Cindy's local. I'm going to put Cindy on the bank account with me so Cindy can help me write checks and do everything. I see it all the time, right? Now, in Mary's will, Mary says that I want everything to get divided equally. A third to my 3 kids. Mary dies. And let's say that there's $20,000 in that bank account where Mary and Cindy were on it together. What happens? Guess what happens? Cindy gets that account. Okay, Cindy has now inherited $20,000 more than her 2 siblings. And guess what happens? Mary can basically hold on to the money. She doesn't have to share it legally. It's her money. I guarantee you that is not what. Or not Mary, Cindy. I'm sorry. Cindy's the daughter.
And Cindy is the daughter.
I was getting confused. So Cindy doesn't have to share the money, right, with her siblings. And I guarantee you, Mary, who died, that's not what she intended. She wanted to go a third. Let me tell you a story. I did a workshop with a lot of people in it not that long ago. A woman saw this slide. She came up to me afterwards, said, I have to talk to you. I said, I can't meet with you now. You got to schedule an appointment. We made an appointment. She sat down with me. She said, you remember that whole thing? I said, yeah, that slide. Yeah. She goes, let me tell you a story. She goes, my mom is from Canada. We're from Canada. And my mom's up there. And one of my brothers lives up in Canada. And then there's 3 siblings in the United States. So there's 4 kids and the mom. Mom had about $1.2 million of assets. And mom said, I'm getting frail. I need help. So she put the son on a bunch of the accounts. Mom dies. Guess what happened? About $600,000 of the 1.2 million were in those accounts that the son had access to, and she put the name on them. The son now gets $600,000. Now he can decide what to do with it. The son said, "Guess what, guys? I'm keeping that money. That's mine." So now there's only $600,000 left, and that gets divided 1/4 to each of the kids, and the 3 other kids will not speak to the brother now, and it's a whole family fiasco. So don't think this stuff doesn't happen on a daily basis, okay? So this is how titling of assets really makes a difference with estate plan. So now we're going to get into a little bit of the weeds here. So I don't want to get too confusing, but we're going to talk about homestead because it's important and it's confusing. So there are 2 different types of homestead we're going to talk about. Number 1, I'm going to talk about number 1 right now. We're going to talk about homestead as creditor protection. Here's what you need to know. Homestead property is creditor protected. What's that mean? That means that if you were to get sued, they cannot touch your homestead property. You are protected. It's a matter of social principle in Florida. They don't want people losing a roof over their head. They don't want that problem. There's only a couple of instances where a creditor can come after you. Obviously, if you don't pay your mortgage, right? The mortgage company can foreclose. Another example, homeowners, right here. Do we have homeowners associations here? In here? Yeah? If you don't pay your homeowners association due, they could put a lien on the house and force a foreclosure, believe it or not. The third is you got to pay taxes on the property or else they'll come. And 4th is the government. They can always come in. Big brother can always come after us. Besides that, no one can touch you with the homestead. So here's a funny little tidbit. if you notice, there's a lot of CEOs and CFOs and major presidents and whatever, and they claim Florida as their primary residence and their homestead. And they have $100 million, $70 million homes, and that's their homestead property. Why are they doing it? Because they know that eventually they might get sued as the owner, president, or CEO of a company. And they know they might come after a lot of assets, but they also know that their homestead property is protected and that they can never come after them. So that's why they claim Florida as a home, and they buy these big real estate deals and put homestead on it. One of the advantages of Florida, very few states have this, Florida does not put a dollar value on the homestead. So you can have a homestead that's $10,000, a small little apartment. You can have a homestead property that's worth $150 million. They don't care. It's all protected. Okay, so that's the first step with homestead. That's homestead as creditor protection. Now I'm going to confuse you a little bit, but bear with me. We're going to now talk about the advantage of homestead with real estate taxes. Okay, and I'm going to use me as an example. So what happens in Florida by Florida Constitution, if you claim homestead on your property, the state of Florida cannot increase your real estate tax from 1 year to the next any more than 3%. That's the maximum they can increase your tax every year. So have you guys all own properties in here?
Yes.
And you claim homestead?
Yes.
Okay. Have you noticed obviously the taxes don't go up dramatically year to year? That's because it's homestead. They're not allowed to. Okay. By Florida's Constitution. So let me give you an example. I bought my house with my wife many years ago in Weston for $359,000. We put homestead on it. And now my tax for 28 years has been based on the homestead, and they can only increase it most 3% a year. There are years obviously where it doesn't increase that much, but there are years where they want to increase it 10 or 12%, but they can't, right? So my tax 27, 28 years later, I think it's like $8,000 a year for real estate tax. A house that is my exact same model on my street sold within the past 6 months for $1.8 million. Their real estate tax is probably going to be about $25,000, $30,000. Same house, but I claim homestead on mine, and I've had it forever, and it's $8,000 versus the same house that someone just bought, and it's probably $20,000 to $30,000 in taxes. That's the advantage of homestead. Understand? Creditor protection and the real estate tax. Now, we're going to get a little more confusing here because I need you to understand this. It's really important. Most people, when they die, they want to have their assets go to their kids. Okay, if you have kids, right? It goes to your spouse, and then eventually it goes to the kids. So here's what happens. We have the property. I bought it for $359,000. It's now worth $1.8 million, way up here. Okay, this growth, and I die and my wife died. It's in both our names. When we both die, we give it to our kids. The growth from 359 all the way up to 1.8. That's called capital gains, right? It's called let's just round it to 1.5 million in capital gains. We have what's called currently stepped up death benefit. So what's that mean? That means that my kids will get the property at the date of death value, 1.8 million, and they'll wash away all that capital gains, which is great. So they can literally sell the property the next day for 1.8 million and not have any taxes. It's pretty cool. Does that make sense? And you can do that with investments and everything else. But here's what happens, and this is what I need you to understand. Again, this is getting a little complicated, but it's important. Let's say that the kids want to hold on to the property and they want to have the homestead on. So what will happen is when my wife and I die, they'll get it at $1.8 million, right? Because that's the date of death value. Now, my kids can claim homestead, but the homestead tax is going to be reassessed at date of death value. So the county's going to say, you can claim homestead, but it's now worth 1.8 million, and we're going to claim the tax on 1.8 million. You can never avoid that. So what happens in real life is you want to leave the real estate to the kids or family. The family gets it, and then they hold on to it. And the following year, they want to keep it. And then the following year, when the real estate cap comes in, mom was paying $2,000 or $3,000, and now all of a sudden they get it. They're paying $8,000 to $10,000. They're like, what in the world happened? That's called they had to reassess the homestead. And there's no way to avoid it. And so what happens is the kids can't afford that and they're going to be forced to sell. So I know it's confusing, but it's really important. Did that make sense? Or any questions? Any questions on this?
Makes sense.
Okay, made sense. Any questions online?
Online, any questions?
No? Am I boring you guys or are we doing okay?
No, we're okay.
We good.
Okay. All right, good. Is it making sense? Maybe not. Yes. I
Yes,
don't know.
yes.
Yes, yeah, we're
Yeah.
good.
Okay, now we're still on titling of asset, guys. Now we're going to talk about real estate titling of assets, but it also applies a lot of times to invest stocks, bonds, mutual funds, all that stuff. So have you ever heard of owning real estate as joint tenants with rights of survivorship? So let's say my wife and I own my property together, which we do as joint tenants with rights of survivorship. What that means is that we both own it. And when I pass away, my wife will automatically get it. Okay, the survivor keeps it. It's called joint tenancy with rights of survivorship. So the survivor gets it. Make sense? No probate. It just automatically goes to the survivor. Now, let me give you an example. So the house is in my name and my wife's name. I die, right? And now my wife gets it, and we own it 50-50. And then if I die, now my wife owns 100%, right? Okay, let's do it in investment property. Let's say that we have an investment property and we have 5 investors. And they all own it equally. So that means they own 20% each. And it's owned as joint tenants with rights of survivorship. One of them dies. That one that dies loses the 20%. It's gone. It doesn't go anywhere. It's gone. Now the surviving 4 each own 25%, right? Because they got it. Now one of the 4 dies. The 3 survivors own it a third, a third, a third. One of the 3 dies. Now it's owned 50-50. When one of the 2 that survive, one of them dies. There's only one left. They own 100%. That's called joint tenants with rights of survivorship. Now let's explain different titling of assets. Tenants in common. So let's say that I own a property with my wife as tenants in common and I die. Normally, if it's joint tenants with rights of survivors, she gets 100%, right? In that situation. But it's now tenants in common. So when I die, my 50% stays with me, even though I died, and it will go down to my family. So if we have that investment property and we own it instead of joint tenants with rights of survivorship, we own it all as tenants in common. The first one of the 5 dies, their 20%, they keep it, goes down the family. See, and then the second person dies, their 20% they keep, it goes down to the family. You don't lose it. So that's the difference between joint tenancy with rights of survivorship and tenancy in common. Okay, here's a question for you, and I want to see thumbs up or thumbs down or however it works here, Kim. All right, I want to see what they said. Here's the question, and everybody, I want to know an answer. Joint tenancy with rights of survivorship, which we just talked about, right? My wife and I own it, and then I die, and then it goes to my wife outright, right? Does joint tenancy with rights of survivorship avoid probate court? That's the question. Yes or no?
Yes.
Give me a thumbs up if you think it avoids probate.
Yes, because it don't.
Okay, here are a lot of yeses on the audience. They're saying it avoids
Thumbs
probate.
up.
I see some
Okay.
ton of thumbs up. You guys are all wrong. Okay, so here's what happens. I'm going to use my wife and I as an example. I own my house with my wife. What happens?
Joe Lisa got a face.
My wife and I own the property as joint tenants with rights of survivorship. I die, no probate, right? It goes to her. She now owns it 100%. Now she dies. What happens? Probate. So it's now in her name alone. So joint tenancy with rights of survivorship does not avoid probate. It delays it until the last person dies. Does that make sense? Yeah, question.
Doesn't go to the homestead.
No. Wait, hold on. I hear it. Hold on. This caused an uproar here. Hold on. Is there questions?
You have questions? Anybody have questions? You can unmute and ask.
I have a question.
Go ahead.
Just for clarity, the tenants in common. If can two siblings have it? Well, just to understand clearly, if two siblings, so me and my sister get tenants in common. If one of us pass away, their 50% will still go to their family or their kids, correct?
Correct. That's the difference between tenants in common, but it's going to go through probate.
Okay.
Your 50%, if you died with your sister and you own the property 50-50 as tenants in common, and you die, you'll keep it, but it's going to go through your will, or if you don't have it, it's going to go through intestate law, and it's going to go through probate court. You understand that?
Okay, so just say my child hypothetically will still have to go to probate for my 50%.
Yes, that is correct. That is correct. So the example I gave with my wife is we own it not as tenants common, but as joint tenancy, and I die. My wife automatically gets it, no probate there, but now she owns 100% and it's only in her name. Now she dies, that's going to go through probate because it's in her name when she died. And that's the same. Who was that was speaking? What was his name?
Marvin Brown.
Marvin. That's the same scenario that I gave you, but it's a different form of ownership. You gave the example of tenants in common between you and your sister. So you each own 50%, but when you die, it doesn't go to the survivor because it's not owned as joint tenants with rights of survivorship. It stays in your bloodline, okay? Because it's tenants in common, and your 50% will stay with you, but it's in your name alone. That's got to go through probate before it gets transferred to your kids or however you have it. Got it?
Okay, got it.
Okay, perfect.
Wait, sorry, one more question.
Yeah.
I know, like you say, going to probate in the state of Florida is usually 3%. So would that be 3% based on the 50% of the property,
Yes.
or is it still 3% based on the total?
3% of what is your share.
Okay, thank you.
Yep. Okay.
Hold on. Anybody else have a question online?
Nope. Okay. Moving on.
Okay.
All right. Here's a rule you guys need to understand. Anything that has a beneficiary form should avoid probate. Anything that has a beneficiary form should avoid probate. What is that? IRAs, 401ks, life insurance, annuities, bank accounts if you have TODs or PODs, transfer on death, payable on death. Anything that has a beneficiary form, when you die, will go to whoever you named as the beneficiary, no probate. Okay? So when we're talking about probate, we're talking about probate of houses and other things, and it could be investments, could be lots of things. Even with assets that I just explained, that you die and you have beneficiary forms, I handle a lot of probate to those. And here's why. What happens if you die and you have an IRA and the beneficiary, there's no beneficiary name? That's going to go through probate court and we got to go through the estate. Or what happens if you name a beneficiary and then that beneficiary and you die, that beneficiary is dead already. And we don't have an alternate beneficiary. That's got to go through the estate of the person, of the beneficiary. So there's a lot of times where even though there's beneficiary forms, I still have to go through probate because people are not following up and meeting with someone like me on a regular basis. Got it? Okay. Now we understand. Now you understand joint tenancy does not avoid probate. It only delays. Okay. All right. Oh, next slide. We're still on titling of assets, guys. We're almost done. I told you it's important. How many of you have kids on an account? I do. I have my son in law school. I got a bank account with him. It's got 10,000 or something in there to give him money. I'm sure a lot of you have kids on an account. Is that a good thing or a bad thing? Bad thing. Why would that be a bad thing to have kids on an account? Because they can write checks. Number one, they can clear you out. That's the number one problem. They can go in and clear you out. So just realize that. That's number one. But what happens if my son Jason, as an example, what happens if, God forbid, my son got in a car accident and it was his fault? and they decided to sue Jason. What's going to be part of that lawsuit? That joint account that I have with my son. Even though it was my money, they don't care. It's in his name too, because of the title.
Wait, the full amount of this.
Full amount, full amount. It's not 50%, it's everything. They come after it all. Okay? Number two, what happens if Jason got divorced? What's going to be part of the divorce proceeding? That account. All of it. Oh, number three. What happens if, God forbid, Jason's not very good financially and he has to file bankruptcy? What's going to be part of the bankruptcy? My money, because his name's on it. So that's the problem with kids on bank accounts, right? And remember that Mary and Cindy example I talked about earlier?
Yes.
That's the problem with that. You saw how that works. Let me tell you another story. I had a story where I did a workshop and a woman came after me right afterwards and said, I have to talk to you. And I said, you got to meet with Carlos to schedule an appointment. And she sat down and met me. She met with me. She goes, you remember the slide about the kids? I said, yeah. She goes, well, I got to tell you what's going on. I said, okay, what? She said, I have one son. He's 44 years old. He's a chiropractor. And everything I have is in joint name with this son. I said, okay. I said, I don't like that. There's a lot of problems with that. You know, people do it every day. And she goes, well, here's the issue. My son is not doing well. He's getting ready to file for bankruptcy. He's not doing well as a chiro. He's going to have to file bankruptcy. And I told her, well, guess what? You're in a lot of trouble. I can't help you. You need to meet with a bankruptcy attorney because there's something called clawback rules. So if we transferred the money out and put it in her name alone, they might have a 2, 3, 4, 5-year clawback rule that they can claw all that back into the bankruptcy if that happened. I never heard from her again.
Wow.
That's a true story that happens in my workshop. Okay. So remember that Mary and Cindy situation we talked about and how which one was the daughter? Cindy.
Yes.
Cindy got to keep the $20,000, right? Because she was on the account. Here's what I would have done differently. I would not have named Cindy as a joint owner of the account. I would have put the 3 siblings on as a TOD or POD, transfer on death or payable on death on the bank account. It's like a beneficiary form. And then I would give Cindy.
Hold on, Lloyd, you have a question?
No.
Okay.
No? And then I would give Cindy signatory authority so she can help write checks when needed. And then by doing that, when Mary passes away, that bank account, whatever is in there, is going to go a third, which is what mom wanted. Okay? So that is titling of assets. That's a lot. I told you it's important. Did it make sense? Any other questions? We're going to fly through the rest of this. How are we doing time-wise? Okay. We're going to be done in 10 minutes, hopefully, if I can finish this up. We'll see. We'll see. All right. Ladybird deeds. I love ladybird deeds. How many of you have heard of it? Not too many. Okay. So here's what you need to know. There's only 5 states in the country that allow ladybird deeds. Florida is one of them. I usually ask, do any of you want to guess what the other 4 are? But we don't have enough people here to start guessing.
Texas?
Texas.
Okay.
California?
California, no. New York, no. Yeah.
Carolina, no.
What?
South Carolina.
South Carolina. The 5 states are Florida, Texas, no, Michigan, no. Florida, Texas, Michigan, West Virginia, and Vermont. I have no idea why those are the 5, but that's what they are. Okay. But here's what you need to understand. I use it every day. Listen, everything we're talking about tonight is general in nature. You need to understand, you need to meet with someone like me to talk about your specific situation. I need you to understand that. Especially when we're talking about a ladybird deed. All right? This is how it works. If I own the house with my wife, and we own it as joint tenants with rights of survivorship, and I die, you guys know no probate, right? Because it goes to the survivor. But now my wife dies, now we have probate court, right? Make sense? Yes? Okay. Yes or no? Okay. Does that make sense?
Yes.
We talked about it, okay? So, here's how it works. I'm going to prepare a ladybird deed, and I'm going to transfer the property from my wife and I. We're going to do a new deed transferring it to my wife and I. Same thing. So my wife and I own it. If I die, my wife gets it automatically, just like before. If my wife dies now and it's in her name alone, normally probate. But we did a ladybird deed. And in the ladybird deed, it allows me to name the kids as beneficiaries on the deed. So when my wife dies, it automatically goes to my 2 kids. In that situation, no probate. Sounds great. Yeah, I do it every day. Yes, question.
So is it better to have a ladybird deed or enhanced life estate?
That's the same thing.
Okay,
The question is it better to have a ladybird deed or enhanced life estate deed? The legal term of a ladybird is called an enhanced life estate deed.
okay, so but we have an enhanced life estate, then we're good.
Yes,
Oh.
yes. But here's the problem.
But.
There's always a problem. Okay? So, let me give you an example of someone I know. Someone did a life estate deed for a widow. She had 4 kids. She did a new deed, transferring it from her to her for her life. She can do whatever she wants with it. She can sell it, doesn't need the kids involved. They're not involved whatsoever, still has homestead, everything's good. The widow dies, then it automatically will go with the ladybird deed to the 4 kids. That's how she had it set up. So that's what she did. She died. Guess what the problem is? There's 4 kids, they get 25% each, right? One of the 4 kids was in the middle of being sued. Guess what's part of the lawsuit?
The ladybird.
The ladybird deed, the 25% ownership of the ladybird deed. And what happened was it was a large amount of money and they couldn't afford to deal with it. So they had to sell the house and give her 25% cash so that she could help pay off the lawsuit.
Oh, wow.
So my point to you is as follows. If we got kids that we don't like their spouses, and there might be divorces down the line. We got kids that maybe are not good financially. We got kids that have to file bankruptcy or something like that. We got kids that have mental problems, all sorts of reasons why we don't want to do it that way. So in that situation, the answer is I would not have done it that way because before I do a ladybird deed, I always find out about who we're giving it to and if we got some concerns. If we have some concerns, the better way to do that is to do a ladybird deed. So we transfer it from the widow to the widow. The widow owns it. She can do what she wants, sells it, whatever. When she dies, the beneficiary in the deed is not the 4 kids. The beneficiary in the deed is her trust. And then it all goes into the trust. And then in the trust, it says to all 4 children. And guess what? With a revocable trust, I can protect the kids from lawsuits, from bankruptcy, from all sorts of things. And so we would wait for the kid to get done with that lawsuit. And then once it's over and done with, they couldn't touch it. That money, once it's over and done with, then we can disperse. So that's the reason. That's why I tell everybody, you got to meet with someone like me to talk because every situation is unique. You have a question?
Can the
Hold on.
can it keep track?
Hold on.
I forgot, let me tell you what you got about.
Okay. Can the ladybird deed be transferred to a trust?
Yes, that's what I'm doing in that situation.
Okay, so I would take the.
So instead of the ladybird going from you to you, and then the beneficiaries when you die to the kids, I would do a ladybird deed from you to you. You still have full control. When you pass away, instead of giving it to the kids, we give it to the trust.
Okay.
And it avoids probate.
So then I don't need issues.
Okay, but yeah, it depends on the situation, but yes. Okay.
Thanks.
All right. So again, here's what there are 5 states. Again, it's Florida, Michigan, West Virginia, Vermont, Texas, and it avoids probate. That's the ladybird deed. Got it? Any questions? Anyone from the
Thank you. Here. Any questions on Zoom?
Just for clarity again, sorry. So like you said, we
That's
currently
Marvin. What's up, Marvin?
Hey, how you doing?
All right, buddy.
All right. So if me and my wife currently own a home, you would say that to do a ladybird deed to ourselves and then place our son as the beneficiary?
Yes.
And that's
Yes.
where if
Special
once
language
both
is
of us
special
pass, he will.
But here's the problem, Marvin. if your son has some issues like bankruptcy issues, or you don't like the spouse and we might have a divorce down the line, or is being sued, or I didn't mention this, what happens if your son or daughter is under 18? We don't want to give it to your son or daughter if they're under 18, because if you died and then they get the house and they're under 18, we're going to have a guardianship, a court-appointed guardianship until they're 18 years of age, and that's going to be a ton of money. So that's why a trust is the appropriate thing. If you have young kids, you need to do trust work. And then it can go into trust, and then you can have your brother, sister, nieces, nephew, whoever in charge of the trust to distribute it to your kid at certain ages or however it wants to go, and there's no court supervision.
Okay.
Okay? Any other questions?
Yeah, I have a question. He sort of answered.
Go ahead.
Sort of answered my question about if there was one area you wanted to air the property to regardless. And you did bring up the fact about other issues that come with when you go directly to the air. My question was about choosing the trustee, the process of that for most people. Who is an automatic trustee, which there are none, but be a good person to be the trustee of an.
Okay, we're not quite there yet, but we can talk about that. Actually, we might be there. Hold on. Oh, no, we're not. We're not. Okay. We'll talk about it now. So I'm going to switch. We're going to lose our. We're going in a different order.
Okay.
We're going to talk about a revocable trust. Okay. Which is what you're talking about. There's two types of trust out there, guys. There's revocable trust and irrevocable trust. Hardly ever do we do an irrevocable trust unless there's a really specific reason. The reason is once you set up an irrevocable trust, you have no control over it. So 99.9% of the time, we want to keep control and be able to do things with the trust. So it's going to be a revocable trust, which means it can be changed. There can be amendments done. Nothing's set in stone until you die. Once you die, it becomes irrevocable because we want your wishes followed. Here's what you need to know about a trust. Just listen up. There's 2 steps to the trust. First step, we got to sign it, witness it, notarize it. We have to create the trust itself. That is step 1. At that point, look up here. At that point, we have this empty box. You can see me. I don't know.
Yeah, they can.
Okay, we have an empty box here. Okay, that's step 1. Step 2, the legal term is called funding or populating the trust. Fancy legal term for filling up the box with assets. The ladybird deed, doing a ladybird deed, putting the real estate in the trust. Got it? So putting all these things in the trust. When you pass away, any assets that are in this box avoids probate court and acts what you guys think of as a will, acts like a will, and it goes to your kids or however you want it to go. That is how a trust works. In the trust, in this box, you wear 3 legal hats. You're called the grantor of the trust. That's a fancy legal term for the one that created the trust. Even though I drafted it, legally it's your document. Number 2, you're the trustee of the trust. That's just like you manage your assets today individually over here. Anything that's in the box that you're managing, you're going to manage as a trustee. Something happens to you, you name a successor trustee, which we'll talk about in a minute. Successor trustee to slide into your shoes, and then they will manage it for your kids or however you want it to go. The 3rd hat you wear in this box is while you're alive, you're the beneficiary of the trust. So if you think about it, you created the trust, you managed the trust, you have the benefits of the trust, you have 100% control, just like you do right now. Got it? Now, the question that you had in the back, you said, how do you name, or is there protocol to naming a successor trustee or successor manager? My answer to that question is, usually you want to name family members, okay? A brother, a sister, or if you're married, it's usually husband and wife are co-trustees. Something happens to one of you, the other one becomes the sole trustee. Something happens to both of you, you're going to name whoever you want to name to be the successor trustee. Normally, I tell people, name someone that's financially responsible, has the same family values as you do. I actually did a workshop that has been recorded, and it's for my private client group, on the roles and responsibilities of a successor trustee. And it talks about how do you pick a trustee, what should they look for, what should you look for as a person or not person. So if you don't name anybody, the courts are going to have to get involved to name somebody, which we don't want, obviously. Usually the beneficiaries will come together and name someone at that point, okay? So does that make sense about the trust? Yes? Now, a trust, in my opinion, makes sense for a lot of people. Because avoiding probate, which is what we're trying to do, it's making sure the assets go however you want it to go. If you got young kids, you need to do trusts. If you have business ownership, you own an LLC or S corporations, we're going to need to do trust work, okay? If you have kids that have special needs, God forbid, we need to do trust work to protect their interests so that they can continue to get government benefits. So there's lots of reasons to do trust work. My job is to sit down with you and to determine, do we need to do trust work? Or maybe I can do the same thing for less money and not do a trust. And a lot of times, everyone comes to meet with me saying they need to do trust work. And it's my job to say, well, what, you know what? You can do it for this price, or I can do the same thing and it's going to cost less money and it's going to do the same thing. And I'll leave it up to you to decide. Okay? But that's what you need to understand about revocable trust. Got it? Now, let's talk about what we call the 4 most important documents. How are we doing on time?
8:21.
Oh, God. Okay, we got to be done in 5 minutes.
Okay.
All right? 5 minutes, guys. 4 most important documents. They're not the will and they're not the trust, which is what everybody thinks. Number 1, durable power of attorney. Number 2, healthcare surrogate. Number 3, living will. Number 4, HIPAA. I'm going to tell you what each of those are. Durable power of attorney. Everyone's worried about dying, which I get. I also worry about what happens if you become disabled or incapacitated. So if you become disabled or incapacitated, we're going to have a guardianship court to handle financial affairs unless we have the trust to deal with things. The durable power of attorney is meant to avoid guardianship and name your spouse or significant other, whoever you want to name, your sibling or whatever, to be in charge of your finances so we don't have to go through the court system. So it's a really powerful document. The other major purpose of my durable power of attorney is, God forbid you have to have home health care, assisted living care, nursing home care, right? If we have to deal with that, if we don't have long-term care insurance, which 99% of the people don't have, they're going to dwindle your assets and your income until there's nothing left before the state will pay for things through Medicaid. With the proper durable power, my durable power is about 35 pages. There's language in there that if you, God forbid, need to go into a nursing home or assisted living, it allows me to legally create legal documents to protect the income and protect the assets for the family overnight so that you qualify and we keep the assets in-house. So it's a really important document, the durable power. Next, healthcare surrogate. Let me switch here. That's durable power. I'm not going through a lot of it. It's just too much. Well, when does it terminate? Durable, here's one thing you need to know. A durable power of attorney stops upon death. People think that they can go to the bank when someone dies and use the durable power and clear out the account. You do that, that's a problem. Okay? When the person dies, the durable power stops. Got it? Okay. Next is the healthcare surrogate. So what happens if I'm in a car accident and I get rushed to the hospital and I broke my arm? And the doctor can either do surgery, not do surgery. He has a couple of options. He wants to talk to me about it. The problem is I'm not awake. I'm unconscious. So who can stand in my shoes to make healthcare decisions with the doctor? That is the healthcare surrogate. It could be your spouse. It could be a kid. It could be a spouse, then kids, whatever. But I usually recommend, if you can, an odd number. So if you have 2 kids and you want to name both kids as the healthcare surrogate, that's usually, I don't recommend that. I do it all the time, but I don't recommend it because what happens if one kid says, I don't want to do that, and the other kid says, I want to do that for mom, for dad. Now we got 1 to 1 vote. We don't have an odd number to break the tie. So I recommend odd numbers. Either do alternates, 1, then an alternate, then an alternate, then an alternate. We do 3 together. Got it? So that's a healthcare surrogate. Next document. It's called a living will. This is also called a dying dignity document or pull the plug document. You get to decide now, while you're of sound mind, God forbid you ever put on life support. Do you want to stay on life support or do you want to take it away? You get to decide so that you don't have to put the burden on your entire family. That's the purpose of the living will. The HIPAA document is what happens if we need to get access to medical records from the hospital or the doctors. They do not like releasing records. They're very close to the vest. They don't like to release things. They have to release it if we have the proper HIPAA documentation in place. So the four most important documents: durable power, healthcare surrogate, living will, HIPAA. Question.
Does this apply to 18-year-old? Does this apply?
Yes.
to years-old?
Yes, the question is, does it apply 18-year-old? The answer is yes. Remember I said at the beginning of the workshop, I said, if you have no money and you're 18, you still need estate planning. So I tell all my kids that go off to college and any kids that are 18 or over, at a minimum, I want a durable power of attorney and a healthcare surrogate. The durable power is so that I can help out with financials and the banks and stuff if they're away in college or wherever they are. Healthcare surrogate is, God forbid they're in the hospital, I want to be able to talk to the doctors. That's why it's important. Great question.
Quick question.
Yeah.
So you can designate a durable power of attorney at any time, and how long does it last?
It's indefinite. So Florida changed the laws. I'm trying to be done here, Marvin, but you asked me a question.
Okay,
So,
I'm sorry.
That's right. Florida used to have something called, back in October of 2011, they changed the law. Before October of 2011, they had something called a springing durable power of attorney, which I love. What that means is that the durable power of attorney didn't spring to life until we had two doctors state that I was disabled or incapacitated, which was great. The problem was the banking institutions, the investment community, et cetera, it was too much of a burden on them because they had to find out if the doctors who approved it or not approve it, et cetera. It was just too much liability. So they lobbied, and in 2011, the state of Florida got rid of that springing power and it became a general durable power of attorney. And what that means is that as soon as the durable power of attorney is signed, Marvin, it is up and running. If you become disabled, it continues to work. So there's a big difference. Got it? And it's indefinite, by the way. Okay, until you can always obviously revoke it. Until you revoke it, it's good, it's still valuable. All right, real quick. Trust work we already talked about. I'm not going to even talk about it because we talked about it. It's private. It's in private. If you got kids with disabilities, we got to need trust work. You got young kids, you need trust work. You got business ownership, you need trust work. All sorts of reasons for it. It is private. Remember, we talked about how probate's public. This is private. The last thing I want to talk about is, well, pet trust. So I have a lot of families that like animals. I'm an animal lover. If you're concerned that you're going to be outlived by your animal, then we can do a pet trust and leave money for the animal to be taken care of. I do that a lot for people in certain circumstances. We have gun trust. So God forbid anyone that owns guns, sometimes if you have enough guns, we need to make sure that it can be properly transferred to the next generation or whoever you want to give to. There's federal laws, state laws, and all sorts of concerns that we have to make sure it's done properly. Otherwise, if it's not transferred to the right people properly, they can claw the estate back in if something's bad happens, and they can come after the estate. That's why we have a gun trust. Last thing I'm going to talk about, blended families real quick. Obviously, if you have a blended family, meaning you're in a second marriage, third marriage situation, whatever it might be, we got kids from marriages all over the place, we need to do trust work. There's no other way around it to protect everybody. Make sure the kids from the first marriage get money, that kind of thing. Last thing I'm going to talk about for 2 seconds is Medicaid planning. I want you to realize that if you know anyone that needs assisted living, home health care, or a nursing home, that we can get them qualified and protect all their money overnight, basically, within a very short period of time. That's all you need to know. Florida allows what's called crisis Medicaid planning. A lot of states do not allow that. Florida doesn't. I get calls daily, right, Carla? Yeah. For clients with family members saying, mom needs to go to assisted living. What do we do to protect the money? And we do whatever we got to do to protect it. We're done. That was longer than I wanted to be, but I'm done. I hope this was worthwhile. What I ask all of you is the ones that are here, there's a evaluation form. I want you to fill it in. The top portion of that evaluation is your name, information, etc. If you want to meet with us, I need you to do me a favor and please fill out a time that would be available for us to try and call you to schedule. Okay, or you can talk to Carlos and make an appointment with him. It's not going to be right away. I'm
You
a
giving
busy
your
guy.
claps and everything, they're clapping and thanking you.
Oh, you're welcome. You're welcome. Real quick, also, where is it? Oh, why I do this? I just want to tell you why I do that. That's the picture of me, guys. 8, 9 years ago, I'm a swimmer. Okay, like swim hard, like I'm in a master swim team, and I swim 3,000-4,000 meters 4 days a week. I was at the pool swimming at the YMCA in Weston when I was 48 years old, and I had a heart attack in the pool. The only reason I survived was because there was a cardiologist swimming in the lane with me. He saved my life. My daughter, who is a nurse practitioner, her last class was on heart attacks. And I had what's called a widowmaker. So I had 100% block of a widowmaker, and they say that for a reason. It means you don't survive. My daughter asked the professor, what's the odds of survival for someone that has a widowmaker at 100% blockage? And the teacher said 99.4% chance of not surviving. So I shouldn't have survived. I survived because I swim, and I've been swimming for years, and I needed extra oxygen to work out, and so my body built collateral arteries. That's the only reason I survived. It created a bypass until I got to the hospital. Here's my point. I was 48. I didn't think I was, we talked about procrastination and you may not have it tomorrow. I shouldn't have had tomorrow. But I was calm in the emergency room because I had everything in place. I just want you to realize you need to put things in place. It's really important. Okay. What I'm offering you guys, I don't know how this is going to work. That'll be another situation. But what I am offering you guys is I charge $600 for a meeting. I'm waiving that fee. Okay. You do not get charged. I'm doing a free consultation for you. It's called a discovery meeting to find out what your goals are, what your concerns are. That includes if you have documents done already, bring them in so I can look at them. Okay. I'm doing that only because of this wonderful young lady over here, Kimberly. All right. Yeah. So, but you got to make sure that we reach out to you, and you got to make an appointment there in a short period of time. It may not be for months from now, but we got to know you want to meet. Okay. And that's it. I'm done. Thank you so much, guys.
Thank
You
you.
can stop recording.
Yes, you can.
There's 3 people that I need contact, if you could tell them.
Okay, 3 people we need contact for.
Erica Delaford,
Erica Delaford.
I'll make sure you get it.
Okay.
Charlotte Williams, and
Charlotte Williams
MHB.
and MHB.
That's Mary. I have that.
Okay, those are the 3 that we didn't have the contact. I will have Alejandro reach out to all of you to see if you want to get together or not. That's your decision. But if you don't, that $600 thing goes away. Okay. Okay, don't worry about it. Don't worry about it. We'll take care of you. That's it, guys. Thank you so much. I hope it was worth your time. I know I got a lot of thumbs up, so I appreciate that.
You do.
Do you mean
This one is actually.
on Saturdays?
No.
We just want to thank Andy for coming out. We want to thank Andy for coming out. We appreciate everybody online. Thank you for taking the time to prioritize yourself and your families. I want to thank Shelby Clark. It's one of the programs to inspiring for the funding activities for partner with meaningful intention partners want to educate families, young adults about how to think independence and of course estate planning. And that remember, if you want to have CPR training for yourself or families, please feel free to contact me so that we can get that done.
Oh, I forgot to mention one quick thing. I have a podcast, guys. If you want to sign up for the podcast, it's free. It's on Apple or Spotify. You got to go on and type in. Are you ready? Here's the name of it. If you don't plan, you're stupid. That's the name of the podcast. If you don't plan, you're stupid. I also have a book coming out October 15th.
They laughing.
October, yeah, I know. The book's coming out October 15th on Amazon, and it's called If you don't plan, you're stupid. So be on the lookout for that. And I also trademark that.
Okay.
All right, thanks, Joy.
All right.
Thank
Okay,
you so much.
thank you. You're welcome. I'm gonna just hang on for a bit to see if there's anybody that that have any questions or need to make arrangements with Carlos. So if you want me to add your name to the list, which matter of fact, I already gave him everybody, so they'll contact you and then you just let them know whether you want to follow through with the appointment. All right? So thank you for your time. Thank you for the extended time, the 5 minutes over. Appreciate you, and I'll be in touch with the next presentation. I'll reach out. Any questions before I let you go?
Quick question. I don't know if he's still there, or I don't know if we can
Yes,
answer.
please, sir.
The durable power of attorney. I know he said we can set that up at any time. Is there any way? I'm trying to figure out the right way to answer this. We stay in Miami, so sometimes if you set it up early, is there any way they can use that without you being incapacitated, or like can someone
Yeah, so
fraudulently use you if you give them?
that's what you need to understand about the durable power of attorney. It's a very powerful document. And remember how we said that we used to have a springing power where it sprung to life? That's what I liked about it.
Right.
Now we have a general durable power. So as soon as you sign it, my friend Marvin, it's up and running. So whoever you name could literally go and clean out your bank account if you want. So that's why two things. Number one, you want to name someone you trust. And number two, you want to keep your legal documents somewhere safe and not release them until it's needed. Got it?
Okay.
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 Yeah, another question.
Yes, quick question, Charlotte.
Okay, hold on.
Back up,
Go ahead.
please. Okay, the bank account, you say POD, and what were the other two? Non-write checks only. Upon
Sorry.
death, and what were,
You were breaking up. Say it again, Charlotte.
the bank account, POD, other one, write checks, and something else.
They're called a PO. It's called a POD or TOD for a bank account. It's called payable on death or transfer on death. Majority of the banks have it. There might be a couple banks that don't have it. If that's the case, move your money.
Okay, thank you.
You had a question.
By any chance, let's say you have property in different states.
Yep. Then we need to do a trust.
Property today.
Yeah.
Also.
Yes.
So trust comes with all of that.
Yeah. So if you have assets and they're all in your company name, an LLC or S corporation, whatever, we need to create a trust. And then only thing we have to do is I have to do an assignment of your LLC or assignment of your corporate shares and name the trust as the owner of it. Everything stays the same. Everything still is owned by your company. That's all we got to do. If you have assets, meaning real estate in other states that are in your name, then we're going to want to hire attorneys in those states and have them transfer it to a quitclaim deed, a very simple deed, transferring it from your name individually into the trust. And then they just record it. I can't do it because I'm not licensed in any other state but Florida. Okay? Okay.
Okay, thank you, everybody. Have a good night and be safe.
Thank you.
You're welcome.
I'm in trouble. Straight